This Honorable Court of Criminal Appeals of Tennessee is now in session.
We are continuing with the February docket, the Western section of the Court of Criminal Appeals. Same panel, Judges McMullen and Dyer and myself. 20 minutes aside. If you wish to reserve any rebuttal time, please let me know when you start your argument. And we've got the same folks helping us that have been helping us all day, and we appreciate that. Go ahead for the appellant.
Your Honor, I'm going to call the case State of Tennessee versus Philip Michael Martinez.
That was a good idea. Thank you. Go ahead, Mr. Ridley.
Good afternoon, Your Honors. Todd Ridley on behalf of the appellant Philip Martinez. If I could have 3 minutes for rebuttal.
Certainly.
Today, I'd like to talk about 2 or 3 issues from the briefs, though obviously I'm happy to talk about any of the issues that the court would like to. But I'd like to begin with kind of the central and primary issues that are addressed in the brief, and those regard the forensic interview that was conducted and the forensic interviewer and her qualifications. So to start with the forensic interviewer herself, the primary issue with this case, or with her testimony, was that she was qualified to testify as an expert witness, and in doing so, essentially offered nothing more than vouching for the credibility of the alleged victim in this case. In doing so, the state, and by extension the trial court, violated well-settled precedent from both this court and the Tennessee Supreme Court that explicitly prohibit the state from offering a forensic interviewer to testify as an expert witness to bolster, or for the sole purpose of bolstering credibility. And that's all that happened in this case. So what led to this was some confusion by the state in the manner in which it presented its case. When it presented one of its investigators, the investigator indicated something that would suggest a reason for why the alleged victim's testimony might be different at trial from what it was in the forensic interview. This led the state to go into damage control. And to address that, they attempted to call, and were successful in calling it eventually, the forensic interviewer. And the forensic interviewer testified as to why a child might change his story from the time of an interview to the time of trial. There was no purpose in offering this testimony and no purpose in offering it through the lens of an expert witness as a forensic interviewer. The only reason you would offer that testimony is to say that the child's testimony at trial is true. That is, by definition, bolstering. And that type of bolstering is improper. And if it's not that, it's irrelevant. If it's not there to bolster the victim's credibility, then it has no relevance at all in this trial. It's just simply the comments of a forensic interviewer that have no bearing on a material issue. Either way, it was inadmissible and should lead this court to reverse. But that's not the only problem with the forensic interview. In addition to having the forensic interviewer testify as an expert witness, the biggest problem is that the state and the trial court admitted the recording of the forensic interview as substantive evidence. Now, as this court's well aware, that happens all the time, but there is a procedure to do so. The statute that allows forensic interviews to be admitted as substantive evidence is clear. It has clear procedural requirements that must be met prior to the admission. Now, it is undisputed that none of those requirements were met in this case. Instead, what the trial court did was, in a somewhat slapdash manner, admitted the forensic interview as substantive evidence and made no effort to satisfy the requirements of the statute. That was error. Now, the state in its brief has contended that this particular argument is waived. That is incorrect. The state says that there was no mention of this statute. That is incorrect. At trial, when this issue came up, and there was extensive litigation when this came up at trial, probably 50 pages worth of transcript in the trial itself is devoted to should this be admitted into evidence. The defense name-checked or checked or cited the statute by number before the trial court, and then at the motion for new trial, cited the statute again by number, and then at the hearing on the motion for new trial, once again, the defense cited the statute by number and said it was improper under that statute to admit the forensic interview as substantive evidence. So that issue was raised and litigated in the trial. Because it was, it's appropriate for this court to review the trial court's ruling under that statute. And because, again, the state offers no meaningful defense, this court should conclude or reach the only conclusion that's really possible, that this interview should never have been admitted as substantive evidence because none of the requirements of the statute were complied. So there's those two issues that surround the forensic interview, and both of them require reversal in this case. Now, the other issue I'd like to talk about is the closing argument. There are two problems with the closing argument in this case. The first is one of a constitutional dimension. Now, at or during closing, the state made the following comment about, we don't know, and here's the comment, we don't know if Mr. Martinez was standing there listening. We don't know if he was in the theater. Nobody can tell you that. Nobody did that here today. Only he knows that. When the state said that, the he in that sentence is Mr. Martinez. What that is a direct comment on Mr. Martinez's right to remain silent. That is a constitutional violation that requires this court's review, and it requires reversal. So the state has responded to that argument not by defending what the DA said. The state has responded by arguing that this issue is waived. It has not been waived. So there are a couple of different things that happened. At the immediate conclusion of the state's closing argument, the defense objected. The trial court dismissed the objection out of hand without further discussion. At the motion for new trial stage, the defense again raised this issue. Now, there's some murkiness right now in this court, and I guess at the Supreme Court too, about the appropriate standard of review for closing argument claims and how they should be preserved. But right now, one thing is clear. The Supreme Court in the State v. Hawkins case indicated that so long as a closing argument claim is raised in the motion for new trial, it is subject to this court's plenary review. If it's subject to plenary review, then this court should consider the merits of the constitutional claim and find that the state committed misconduct by commenting on Mr. Martinez's right to remain silent. There's a second claim regarding the closing argument. The next part is not of a constitutional nature, so it's not subject to de novo review. It's the standard abuse of discretion review that would apply to all closing argument claims. But it's one that comes with a direct corollary or direct precedent from this court in the form of State v. Charles Williams, a 2006 case out of Nashville that's cited in the brief. And it's about a DA using his or her kind of stature, I suppose, as a DA to vouch for the quality of a case. And in this case, what happened was the DA said, you don't just admit to sex crimes, you know. My partner, another DA, thinks it's easier to get an admission out of a murder case than it is a sex crime. Now, that statement has a direct corollary in the Williams case. In that case, here's how the court described it. The state's closing argument was essentially the prosecutor's personal expert opinion that his years of experience prosecuting criminals taught him that murderers, drug dealers, and others accused of serious crimes will freely admit their criminal activities in a court of law, but sex offenders deny their crime. That statement and that description of that statement by the court was found to be reversible error. In other words, the court said, the DA can't do that. The DA can't say, because I'm a DA, I have this special insight, special knowledge about the way criminals act. Now, some of them will freely admit that, sure, I did that, but sex offenders will never do that. And the DA in this case is doing the exact same thing. The DA is saying, look, of course he denied it. Of course he denied it in his interview, but all sex offenders do that. And I know that because I'm a DA. This DA in particular had opened the case during opening argument or prior to opening argument, I think it was during voir dire, and said, I'm the sex crimes prosecutor in this district. So when she was saying all this, she is saying, I know how these particular crimes work. I know how these criminals behave when they're talking to police. And because of that, you can count on me to tell you the truth about how they'll behave. And they're going to behave differently than other type of criminals. And I know that because of my position. That was improper. And because this issue has been preserved, and because there is a direct corollary, direct precedent that says DAs can't do this, this court should reverse for the same reason as the court did in Williams. Those two things, especially when taken with its prior comment on Mr. Martinez's right to remain silent. This was a very close case. It relied extensive or pretty much solely on the alleged victim's credibility. And because of that, any little thing that, whether it's evidence, whether it's the form of expert testimony that was improperly admitted, whether it's from a video recording that was improperly admitted, whether it was this extra statement by the DA about Mr. Martinez's right to remain silent, and finally the statement about essentially vouching for the credibility or vouching for the quality of the evidence, all these things add up and ultimately cause Mr. Martinez prejudice in the form of leading the jury to reach the conclusion that the state wanted it to reach. So those are the two central issues I wanted to talk about. There are two other issues, just a sufficiency challenge, and that's addressed by both sides, I think, in the brief sufficiently. And then there's a flight instruction issue that I think is fairly straightforward and self-explanatory that's also addressed in the brief. So if there are no questions from the court about the two central arguments, which again are about the forensic interview and the testimony surrounding it and the closing argument, Mr. Martinez would ask this court to reverse and based at least on those two arguments, remand for a new trial.
On behalf of the appellee.
Good afternoon, Your Honors. May it please the court, Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should affirm the defendant's conviction for attempted aggravated sexual battery because the trial court properly allowed the forensic examiner to testify as an expert, properly admitted the forensic interview, and properly instructed the jury on flight. Additionally, the state did not improperly comment on the defendant's right to remain silent or offer any other improper comment during closing. The defendant is not entitled to relief on any of these grounds. Turning to Ms. Cindy Turner's testimony as an expert witness, the trial court properly acted in its capacity as a gatekeeper by allowing Ms. Turner to testify in this capacity. Under Tennessee Rule of Evidence 702, an expert can testify if their specialized knowledge will substantially assist the jury to understand the evidence or determine a fact in issue. Now, the Tennessee Supreme Court, in the case of State v. Ballard, has previously discouraged expert testimony about the, quote, child abuse syndrome, or otherwise offering an opinion on an ultimate issue, such as whether a minor was a victim of child abuse or whether the minor victim was credible. That is clear. But here, Ms. Turner's testimony assisted the jury and did not bolster the minor victim's testimony. In this case, Ms. Turner did not offer an opinion as to why the victim partially recanted or whether the victim was abused. Thus, there was no bolstering in this case. And she did not offer an opinion as to an ultimate issue. Moreover, her testimony served several purposes. First, her testimony reduced jury confusion. The jury could have easily been confused after hearing PB's testimony and then hearing Detective Mitchell's testimony. In the forensic interview, PB denied that the defendant actually touched his penis. But at trial, PB testified that the defendant did touch and squeeze his penis. Thus, the forensic interviewer's testimony would have helped the jury properly weigh these differing testimonies that they heard. Additionally, Ms. Turner's testimony assisted the jury in understanding the purpose and protocols of a forensic interview. She thoroughly explained how she conducted the interview, her role in it, and all of the different procedures and protocols that were followed. Finally, her testimony helped the jury weigh whether PB's disclosure was affected by his mother's comments to him or could have been affected by the delay. Thus, for these reasons, the trial courts properly admitted her testimony as an expert witness in its role as a gatekeeper. To address the defendant's corollary issue regarding the forensic interview, the defendant has waived this issue. As the defendant noted, there was extensive discussion about both Ms. Turner's testimony and the admission of the interview. And once the trial court determined that it would admit Ms. Turner as an expert witness, defense counsel at that point advocated for allowing Ms. Turner to testify as a witness. She stated that allowing Ms. Turner to testify without the forensic interview was highly prejudicial, misleading, and confusing to the jury. That can be found in the record in Volume 4 on pages 269 through 70. And on page 274, defense counsel said, "I think if you let Ms. Turner in, you let the interview in." The next page she said, "Otherwise, it's far too confusing to the jury." Thus, while the defendant may have initially objected to the admission of the interview, once the trial court determined that Ms. Turner's testimony was admissible, the defendant effectively abdicated any objection. And even if the defendant made a general objection, he did not specifically object on the grounds that he is objecting to on appeal. And in State v. Long, which this court decided in 2016, in a very similar case, the state sought the admission of a forensic interview, but the defendant failed to raise a specific objection at trial to that interview. And this court held that the defendant had waived plenary review of his allegations on appeal. And if this court chooses to conduct a plain error analysis, the defendant is not entitled to plain error relief. While the trial court did not make specific...
I want to back you up for a second and make sure I understand your argument about this. So this defendant objected to the expert testimony and to the interview. And then when the trial judge said the expert can testify, the defendant felt, well, if you're going to let the expert testify, I need the interview to come in because I need to be able to ask some questions of the expert based on the interview. Is that correct? Is that a correct reading of the record and your argument?
Yes, Your Honor. On page 277 of the record, the trial court noted that, defense counsel, I know you don't think Miss Turner should testify at all. And Miss Berkeley said, no, I don't. But then the court says, now, are you going to play this interview before she testifies? And the state said, well, we're not necessarily asking for the interview. But then the court noted, but earlier you said you wanted the interview if Miss Turner is testifying. Well, so
that's, I guess the question is, if I understand your argument, the trial judge is in a sense forcing the defendant to waive an objection because they forced their hand on another issue. That doesn't seem right. I mean, if I understand what happened, the defendant doesn't want the expert and the defendant doesn't want the interview. But when you say, nope, the expert's coming in, the defendant's like, well, I want to put the expert in context, so now I got to have the interview. Well, they still don't want the interview in because they don't want the expert in. And so just because you as a trial judge have changed the rules, so to speak, doesn't mean that later down the road I still can't have my objection to the interview coming in at all. You forced my hand to let the interview in. I mean, I can see where this is not waived because they never wanted the interview or the expert in.
Your Honor, the defendant still failed to lodge a specific objection. At that point in the trial, the defendant could have easily stated, Your Honor, I understand your ruling, but I continue to lodge an objection on these grounds and list the specific grounds that he's raising now on appeal. But the defendant failed to do that. Thus, the trial court did not make any findings about the defendant's specific objections.
I guess my point, as we can move on, is you've tied his hands because what the last thing the defendant wants to do, if the defendant doesn't want either thing in, and you let one in and he feels, well, once one in, I have to have the second in order to attack the first, he's not going to object to the second at that point, because if he does, oh my gosh, what if he actually wins the second objection? And now you have the expert with no report. You've tied his hands. So I don't know why he needs to make a second objection saying, Your Honor, I understand your ruling. I still object to this piece of evidence coming in, but by the way, I need this piece of evidence to come in. That doesn't make sense to me.
I understand your concern, Your Honor, but it's the defendant's burden to preserve the record for appeal. And even if this court considers the general objections made at the beginning of all the discussion, the defendant still failed to specifically object on the grounds that he's raising now. But in any event, whether this court considers this issue under plain error relief or under plenary review, the trial court properly admitted the forensic interview. This during a jury out hearing, during a proffer, as well as during trial, the state extensively voir dired Miss Turner about her interviewing skills and about the particular interview. And while the trial court did not specifically cite to Tennessee Code Annotated 24-7-123 and go line by line through the statute, making specific factual findings, the interview was admissible under that statute. It's clear that Ms. Turner was eminently qualified and followed the requirements of this statute. Thus, the admission of this forensic interview did not adversely affect one of the defendant's substantial rights and did not breach a clear and unequivocal rule of law. To address the defendant's contentions about the improper prosecutorial argument, if this court has no further questions about that issue. All right. Again, the state contends that the defendant waived his allegations as to the alleged comment on his right to remain silent. At the end of closing, as Mr. Ridley noted, the defendant objected, but he objected to, quote, statements made in closing argument about the credibility of the witnesses. And then later he objected on the ground that the state expressed a personal opinion, quote, as to the truth or falsity of any testimony or the guilt of the defendant, and that the state inflamed the jury. Never during this objection did the defendant raise a constitutional challenge arguing that the state impinged on his right to remain silent. And thus the defendant has waived because these grounds that he raised, this general objection, he cannot now come back on appeal and make a different argument.
So why don't we get there under plain error, though?
I'm sorry, Your Honor.
Why can't we get there under plain error?
Because a general objection does not preserve the issue properly for appellate review. If the defendant had specifically objected on the ground that he raises now, the trial court could have made factual findings about it for this court to review, but the defendant failed to preserve the record for appellate review. He failed to lodge that specific objection.
Okay, assuming it's waived. Assume it's waived. What about plain error review? I mean, this is a constitutional claim he's making.
I'm not sure I understand your question, Your Honor.
Well, give me the plain error review analysis of this, because I mean, assuming he waived it.
Oh,
he's now
okay.
raised it, and how do you say he doesn't qualify under plain error?
Yes, Your Honor. Here, this was not a breach of the clear and unequivocal rule of law. There's no evidence that the state intended to comment on the defendant's right to remain silent. The state was simply arguing that the defendant's action of leaving the movie theater was some indicia of his culpability. It showed that he was guilty for committing the offense. Moreover, the jury would not have taken this statement to be a comment on the right to remain silent. The state had a source of evidence that contradicted the defendant's statement to police and his arguments at trial, the victim's testimony. Additionally, the trial court instructed the jury that counsel's argument was not evidence, and this can be found on page 27 of Volume 1. Additionally, Your Honors, the lack of objection could have been tactical. The defendant responded to this comment in his own closing. On pages 390 through 91, the defendant contended that his early exit from the theater was not evidence of his guilt, showing that even defense counsel took this comment to be an argument that the defendant's flight was evidence of his guilt.
But the state arguing that, hey, by leaving the movie theater early, is something you should interpret as flight and therefore a guilty conscience or evidence of guilt, and him then responding saying, no, I left the movie early because somebody wasn't feeling well, or that wasn't is one thing. But for the state to say only he knows is more than just saying, hey, the fact that he left is a sign of guilt. I mean, the state in its closing saying no one on earth can tell you why he left except for him. And this is basically what it says. And oh, by the way, he didn't tell you that. That's how I read this quote from the defendant's brief. That's more than just saying, hey, flight is a sign of guilt, or can be interpreted as a guilt. I mean, no one knows this proof but him, and he didn't talk. How do you not read that quote that way?
Because that final aspect of the comment was so short and minimal that there's no evidence that the jury would have taken that as a comment on his right to remain silent. The majority of the statements that the defendant objects to refer to the defendant's flight. Thus, any impact from that final comment would have been minimal, and the jury would not have interpreted it that way. To address the defendant's additional argument regarding the closing argument, this case can be distinguished from State versus Williams. In that case, this court reversed the convictions based on the effect of the prosecutor's comment. But here, the General McEwen did not rely on her own expertise and prestige as a basis for her comment. Rather, she relied on her co-counsel. Additionally, the argument was aimed at challenging the credibility.
What difference does that make?
Your Honor, she was again, to distinguish it from Williams, she was not vouching for herself. Additionally, the argument was aimed at challenging the credibility of the defendant's statement to the police department. The state argued that the defendant admitted to everything except what he actually did. But even if this court concludes that this was an improper comment, there's no evidence that the comment affected the verdict. The defendant waited until the end of the complete closing argument to object. If defense counsel had been truly concerned about this comment, then objecting immediately after the comment would have allowed the trial court to intervene and possibly take action if the trial court felt it was required. Additionally, the defendant did not request a curative instruction. The comment was brief and isolated, and here the evidence weighs greatly in favor of the defendant's guilt. And additionally, as noted prior, the trial court instructed the jury that counsel's argument was not evidence. And unless this court has any further questions, to briefly touch on the flight instruction. Again, there was no contemporaneous objection. In the motion for new trial hearing, defense counsel claimed that she objected off the record, but there's simply no evidence of this objection. And this court cannot consider the argument of counsel at the motion for new trial hearing as evidence. And again, there was no plain error by this flight instruction. The trial court's decision to instruct the jury on flight was supported by substantial evidence.
What evidence of flight do you have?
Your Honor, Mr. Mark Ryan Crooks saw the defendant leave the theater and talk on a phone. The defendant then re-entered, grabbed the children that he was with at the movie theater, and left before police arrived. Ms. Sherry Crooks also saw the defendant leave before the movie that he was watching ended, and she noted that the defendant seemed concerned and in a hurry. And 4 days later, the Memphis police found the defendant at a residence. This proof was enough to raise the issue of a flight instruction.
So if I don't know that anyone is accusing me of a crime, and I leave a movie theater early because my child or what needs to leave is not feeling well or whatever the case may be, and therefore I'm concerned because it's a kid that's with me, therefore the state's automatically entitled to a flight instruction?
Your Honor, that was the defendant's theory of the case, but the state's proof here was enough to rise to the threshold level of the trial court instructing on flight.
Let me ask you this, and then I'll let you finish your argument. But what's the state's understanding? What's the state's proof? That the defendant knew that they were looking for him, or however you want to say it, that flight was needed. I'll give it to you. He left early. And you even have proof that someone said he seemed concerned. But in order to get flight, you have to you also have to have some threshold showing that he was trying to flee from a crime, not just that he was leaving a movie early.
Yes, Your Honor. When considered with the additional evidence, it's clear that the defendant, the fact that he went outside, he left the theater, went outside and talked on his phone and looked concerned, then came back in and grabbed the children. When you look at all of those circumstances together, it leads to an inference that the defendant knew that PB had reported the crime, that he knew he needed to get out of there and leave before the police arrived.
Where's step 2 of flight?
Your Honor, I'm not sure.
Subsequent hiding out. What's the proof of that?
Oh, that was the fact that the Memphis police could not find him until 4 days later.
And where did they end up finding him, though?
At a residence. It was unclear whose residence it was or any other details about the residence.
They found him where he lived, didn't they? Isn't that where he lived?
Your Honor, I don't recall that from the record, but that could be true. The record will speak for itself.
Was there proof about them, the Memphis police, trying to find him and couldn't?
Not specifically, Your Honor. Just the fact that it took them 4 days to find him.
Okay.
And unless this court has any further questions, I will rest on my brief for the sufficiency argument. And the state asked this court to affirm the defendant's conviction for attempted aggravated sexual battery. Thank you.
Okay, thank you. Rebuttal?
Good afternoon again. I guess I'll start with the flight issue, since there seems to be a little bit of confusion about that. The Milan police found Mr. Martinez at his residence 4 days after the report, but it was immediately after they started looking for him. They started looking for him. They went to his house. They found him right away. He voluntarily voluntarily went with the police to the station and talked to them freely. There was absolutely no hiding out. So step 2 of flight was not established at all. And Judge Dyer, to your question, this is no different than if anybody else were outside the theater talking on the phone and left the movies early. Under the state's theory, they could get a flight instruction had they been charged if they then found them at their own house a few days later. That's simply not enough to establish flight, either the first step, but certainly not the second step. There was just absolutely no hiding out at all, certainly when you're at your own home, or not, it's not his home, but it was at the home where he lived. I guess I'll turn next really quickly to Your Honor, or Judge Dyer, some of your questions about the first issue. The trial court itself was confused about the way this issue was raised, referring to the state's kind of theory of admissibility as a twilight zone at one point. And that is exactly for the reason Your Honor discussed. The state essentially was saying, defense, you either object here or you don't object here, but either way, we're getting it in and we're getting this expert to testify. And at a certain point, the defense was left with nothing else other to do than say, I object to all of it. But what the defense did in this case was even more specific than that. The defense cited this statute we're relying on now, by number, said, Judge, they have not established the procedural requirements of the statute. What the state's doing now, all of a sudden, I think for the first time at oral argument, it's not even in the briefs, is saying, well, we kind of sort of did comply with that statute. We kind of sort of hit all these marks. They did no such thing. They absolutely did not meet the requirements of this statute. They did not establish that she was a qualified forensic interviewer even, let alone meet the requirements under the statute. The trial judge made none of the necessary factual findings. And because of that, this court simply can't apply the standard of review that it would typically apply to decisions made under 24-7-123. That's because the trial judge didn't do anything. And so on that issue, I'll certainly agree with the trial court on this and this alone. This was confusing in the way that the state tried to do it. But after that, the defense did everything it could possibly do. It objected at every turn, objected by citing the statute explicitly, and preserved the issue for this court's review.
So let me ask you real quick, and what you just said makes sense to me. I now have a better understanding, but I still want to get one point of clarification, and that is, so you defense counsel, objected to everything, but once he said the expert is testifying, is not the defense at that point saying, well, if she's going to testify, we want to at least be able to cross-examine her or put her testimony in perspective with the actual interview and just not let her testify coldly. While we still object to the interview coming in, if you're going to let her testify, we got to at least have this. Is that?
I think that's exactly what happened. So the state really wanted the expert to testify, so there's an objection to that. And then to kind of give context for her testimony, if she was going to be allowed to testify as an expert, the defense agreed that this video should come in just so there's some context that the jury can understand. But I think for purposes of waiver, the important thing is we're objecting to all of it. And then once the trial judge makes one finding, we're kind of stuck. Well, we actually do need all of it if we're going to have part of it. So I think really Your Honor's recitation of what happened is correct, though, again, the trial judge himself referred to this as kind of a Twilight Zone situation, which is sort of kind of right. But ultimately, what the defense did was sufficient to preserve this issue for review, which is really the only thing we're arguing about at this point. And if it's preserved for review, then I think it's certainly reversible error. Yeah, real quick, I know I'm running out of time, but just on the last thing, if for whatever reason, if the court finds plenary review of closing arguments not appropriate and we're doing plain error, there was nothing about this that was tactical. The defense did everything it could other than object immediately after the offending statement. At the immediate conclusion of the closing argument, the defense objected. Now, there's some discussion of, well, there wasn't enough objection. There wasn't a request for further instruction. The trial court's dismissal of the objection was curt and conclusory enough that it kind of ended the discussion. So this defense counsel stands up and objects. The trial court says overruled. We all move on. And this has to go to the jury at that point. So whatever else, this was not tactical. At every stage other than the critical one, and I'll certainly admit that, there was no immediate objection. But after that, the defense did everything it could do to object to the offending statements. And in doing so, I think makes clear that this was not tactical. And if it's not tactical, there's really no other plain error argument that can withstand scrutiny. This was a deeply offensive argument. And Your Honor, when you quoted it, I could not agree more. It cannot be read as anything other than a direct statement on his right to remain silent. It's pretty close to tell us where you are. It's not exactly that, but it's pretty
careful. Some of us may have argued that case. Be careful.
I understand. That was a little bit on purpose, but yes. It's close enough to that to, I think, at least raise the court's eyebrows about what the DA was attempting to do in this case. And for that reason, if we do wind up under plain error, I think it certainly qualifies. But again, based on the Hawkins decision, I think plenary review is appropriate. And if so, reversal is required. And so for all of those reasons, we'd simply ask this court to reverse. And based off kind of the issues we've been arguing about, most likely it's going to be remanded for a new trial. But just in general, reversal based on all these issues is required.
All right.
No further questions. That's all I have. Thank you.
Thank you all for your arguments.
This honorable court is now in recess until 3 p.m.